approaching on the Matthew Gomez case, and Judge, he's here and it's on your bond docket, but there's a BVR issue. I've talked with the state about it.
Okay, so right out of the gate, mental health diversion versus a felony assault on a peace officer? This case just went from paperwork to chaos. Buckle in, because this isn't your average bond docket. Dispute.
Talk to them about what I think are some interesting issues, kind of by way of background in our case. And the state had previously offered, though we had not yet gotten the contract, to do a 90-day mental health PTI, which we felt was appropriate. They're going to review with the felony court to determine whether they still believe that may be appropriate, but they can't do that at the moment. They're going to have to get some feedback and find out a little bit more information about the new felony charge. I read the cases and think there's issues with both of the cases. But there is the pending BVR based on having picked up the new felony charge and need to...
Is he here?
Yes, he's here.
Come up.
Yeah, call him up.
Please.
And it's not really our issue to delve into, but I think there's issues with the way the police officers maybe made the stop in the new case. And
if he's picked up a felony offense, I'm very upset.
We understand. And
let me express my disappointment with you, Mr. Gomez.
Yikes. Assaulting a police officer while you're already out on bond? That's like setting your own legal house on fire while holding the extinguisher. This is more than just bad timing. This could tank any chance at leniency.
You picked up a felony assault of a peace officer while you're on bond for this case. What happened, please?
So in the felony, the officer dispatched to a suspicious person call at a closed gas station. They observed the defendant walking around the vacant lot holding 2 glass bottles of Corona beer, indicating possible intoxication. They attempted to stop and identify the defendant, but he ignored commands and walked away towards the main road. And despite multiple warnings, he refused to comply, and he threw a glass bottle at an officer before fleeing on foot. Officers pursued the defendant for half a mile before detaining him, and while being transferred between patrol units, the defendant had already moved his hand restraints to the front of his body, and the officer attempted to reposition the restraints behind him. That's when the defendant pulled away and struck the officer's left thumb with his elbow, causing pain, redness, and tenderness. And then the defendant attempted to flee again, but was taken to the ground.
And I think there's issues with walking up and saying, we see someone and no more. Well,
it's not our case to litigate.
Well,
all I know is that you've now picked up a felony case. Where'd you going? I got to take him.
Well, Judge, if we're going to be revoking him on that, then I do think it is our issue to delve into. And I think there's issues with the way he stopped. And, but if that's going to be the basis to revoke him, then this court doesn't. But the entirety of the information that the officers receive is based on what I would contend is an illegal stop. You can't just walk up and say, without more, there's no reason.
Go up to a guy and say, hey, let's talk.
No, that's not what they said. They said, walked up and said, show me your ID. And that's an illegal detention. That is a detention, and it's one that's unlawful under the circumstances.
I don't know.
Well, I'd like to set it for a hearing if we can do that.
Sure.
And he posted bond, $10,000 in the felony case. We think that's sufficient to ensure that he appears for a hearing, a formal hearing on it, without needing to take him into custody. I've talked with his mother. His mother has had good contact with me throughout this process, and she'll ensure that he's here. I think if we set it for early next week.
This is where things get legally spicy. The defense is arguing that the police stop was illegal, meaning everything that followed, bottle throwing, elbow strikes, could be tossed out. Sound familiar? That's the fruit of the poisonous tree doctrine.
And we can delve more into the felony case and figure out if the mental health, and I think the state can get an answer about whether mental health treatment is what's appropriate. We think it's appropriate, and even if you delve into the background of our case, the allegation is that he called the police himself and said, hey, I've got traffic tickets, come arrest me, come to my home and arrest me. An allegation, and that he also said, and when you get here, I'd like to be in a fight. And when the cops arrive, they oblige him, they put their tasers away and fight him. And that's consensual conduct. And whether we like it or not, humans have the ability to consent in physical fights if they like in Texas. And it may not be something that we would do or agree with, but legally people are entitled to do that. And so he's not resisting arrest even in our case. So we think there's issues in our case, but we thought on the defense side that it may be more appropriate to go the Harrison route and see if mental health PTI.
I appreciate your argument. I appreciate your tenacity, But I have to be fair to every single person that comes through here. We have certain standards and procedures that we follow.
Sure.
When anyone picks up a felony case, especially a violent felony case, we revoke the bond and we put them in custody. We cannot continue to act in this manner. We are a civilized society and actions have consequences. I'm happy to.
There it is, the gavel drop moment. The judge is crystal clear. Felony violence equals bond revocation. No debate, no delay. This is standard procedure, but the defense is about to put up a serious procedural fight. Stay tuned.
Give you a hearing, but
Yes.
no, I'm taking you into custody. You picked up a felony assault of a peace officer.
Judge, and my position respectfully is, if he's entitled to, Judge, maybe before he be taken away, we finish this portion of the hearing, I think he's entitled to be president. But we think it also a part of due process that before a revocation occur, that you're entitled to both notice and an opportunity to be heard. And if they're going to be seeking to revoke his bond, then under our rules of evidence, it's very clear in Rules of Evidence 101 that a revocation, the rules of evidence apply. And everything that's gone on this morning is a proffer by the state, and I respect the proffer, but that doesn't meet the standard for the rules of evidence, and that's why.
The judge found that there was enough probable cause for a felony office to be filed against him.
Sure.
I
and
don't want to relitigate a felony case here in misdemeanor court.
and I think
So-
that's fine. Well, but I think we're entitled to if we're going to be, and that's what the hearing would be for. But that
One of the
finding,
conditions of his bond is
Sure.
not to pick up any new cases. He's picked up a new case.
and as an evidentiary matter, there's been no presentation that he violated the conditions of bond. I know that you can look in your system and even take judicial notice of that court's finding, but that finding and pleadings that charging him with a new crime, those are not self-proving. And if they're not self-proving, then there's no actual evidence that's been presented. And we'd be entitled to ask questions to prove up, for instance, that they illegally stopped him. There's no basis for that detention. And so respectfully, I'd like to say,
Not going to relitigate the felony case. I'm not going to. You know, I respect your position, but I'm not going to.
well,
He violated a condition of his bond.
says who?
Says a felony court magistrate that put on the case again. That
He's entitled
filed
to be
it.
heard on that. And
And he did in felony court.
I don't believe that that's,
He goes in front of a magistrate. He has a defense lawyer in the magistrate, you know, when they do the magistration. So he does.
well, I think he's entitled to be heard here. If you're going to revoke his bond, I think he's entitled to be heard here. And that hasn't happened. And it certainly hasn't happened in accordance with the rules of evidence.
Yeah, I would just say that, just reiterate that a district court has found probable cause in this case. To say there's no evidence that he violated condition of bond is flat out wrong, because a district court judge has found probable cause on this bond, and she is picked up.
And that's not self-proving. Otherwise, in trial, they could just come in and bring in that piece of paper that finds probable cause and submit that as evidence, and they can't. That's not evidence. Those are not self-proving findings.
We're not in a trial here,
Well,
right?
Well,
You know?
no, I know it's
This is
not.
just, we're having a bond hearing.
Sure.
He's violated the condition of his bond. I understand that you don't like it. I appreciate your tenacity, but
Disagree with you.
and reasonable minds can differ, but he's picked up a felony case and there's a certain process that we follow.
Well, and so we'd like a hearing on that.
Yes, I will give you a hearing. Yes, but I'm taking him into custody because he's revoked and he's a danger to the community. I find by clear and convincing evidence, he refuses to comply with his conditions of bond. Goes with you. I'm sorry, Brian, but I mean, really,
Well-
every case, when they come in here and they pick up a new case,
I
it's
respect.
just especially a felony assault of a peace
I
officer.
understand.
You know,
I just believe that it puts the cart before the horse to make the decision to revoke based on pleadings when case law is abundantly clear that pleadings themselves are not self-proving and that the rules of evidence apply in a revocation proceeding. It's in Rule of Evidence 101, I believe. And nothing that has taken place this morning has been in accordance with the rules of evidence. I understand the court's, I understand that as a historical matter, folks come in and proffer information and I proffer information and we don't do it from an evidentiary standpoint. And that may be what the hearing would serve to accomplish. And so if the court's position is after a hearing, you'll revisit the issue about whether to reach a final decision to revoke his bond or not, then we can respect that.
sure, I'm happy to do it.
Okay. And in the meantime, I guess I do need to request that the bond, a new bond be set in an amount that he can,
Of course, yes.
in the event that his family elects to get him out before the hearing. And in light of our
What I
discussion,
normally do in these types of cases, I always set it at 5,001. Okay? If you reach out to the family and they have a problem, then we can talk about it.
well, and I'll let the court know, the bond was set at 40,000 in the felony case and reduced to 10,000 because the family doesn't have a bunch of resources. His mother is worked to get him out on bond on that case and is going to have to do the same here, but it's really money that's coming out of the mother's pocket. And so which my whole position was get him access to resources. Now we're diminishing resources, and I respect that, I understand, but it's the mother's resources, not his. And so, and the mother, and we knew that
And I hope-
issue was coming up this morning, and he showed up. And that's part of the goal, is to ensure that he appears, and he did, and to ensure the safety of the community. And I think that part of the finding will address the hearing. But I've been,
What do you want as far as the bond?
well, I'd like it to be at 2,500. And
Say,
Stay with our rate for 5,000.
okay, when I have this kind of issue, I always split the puppy. So I'll set it at 3,750. Okay? If there's still an issue, come back and we can talk.
yes.
But there has to be a sufficient so that he understands, right?
Well, and part of the discussion was, do you really get to that point of understanding if, for instance, the allegation, even underlying our case, is you call the police and say, come arrest me, I've got warrants, supposedly telling on yourself. But when you get here, I'd like to engage in a fight. And then they come and oblige him. I don't know that that's even resisting arrest. And so,
Well, it seems like to me that he's just trying to take off the whole time. He's trying to physically, or he's evading the entire time.
No, I think it's
When he
case two.
throws something at
that's
the
the felony
officer.
charge. I'm talking about our underlying.
Oh, our case. Okay, I'm sorry.
And I think probable cause had been heard before I even got appointed on that case. But I think even revisiting those facts, I've talked with the state at length over the course of settings. And my position is, if you invite someone to a fight and they say, sure, we'll engage in a fight,
If you want to set this for a formal probable cause hearing on the resisting, I'm happy to do
well,
it.
we may address it the same time we do the bond hearing on the same case,
I'm
if
happy to
that's
do it.
appropriate.
Absolutely. I'm always willing to revisit probable cause,
Yeah,
always,
I know.
at any time, whenever. So just if you want to set it for 3 days, we can have a formal probable cause hearing on the resisting, I'm happy to do it.
It may give the state a chance to find out what felony's position would overall
And
be.
that's, I mean, that's state's, but I don't want to litigate the felony. I wouldn't think that's proper. I understand they're entitled to a hearing, but district court judge is not probable cause on this. I'm not going to be in a position to litigate the felony now.
Let's set it for 3 days,
Yes.
set it for the hearing, let's do probable cause as well on the resisting, and then we'll come back and be ready, and then if you can show me that there's no probable cause, I'll find no probable cause, then we're done. That's it.
All right, plot twist. New defendant, new drama. From terroristic threats to a stuffed animal concealing a knife, this just turned into a courtroom episode of Law and Disorder Texas Edition. Let's see how the court handles this wild turn.
I appreciate it as always, Jim.
Absolutely.
Thank you. Thank you.
Mr. Ladon, you are on bond for a terroristic threat. You've now picked up a criminal mischief. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 11th, 2025, the officer responded to a physical disturbance at a residence in Harris County, Texas. Dispatch advised that the caller was reporting he had a knife and was going to stab someone because they were bothering him about a broken window. The officer made contact with the defendant and the complainant, and the defendant stated he called the officer. The defendant was found to be in possession of a green stuffed animal which had a fixed blade kitchen knife concealed inside. The defendant stated the complainant came to his house with her roommate accusing him of breaking a window at her apartment.
Whoa, hold, you're going really fast.
Yes, Judge.
The defendant,
Called the officer.
okay,
He said that the complainant had come to his house with her roommate, accusing him of breaking a window at her apartment. The defendant stated he was walking back to his apartment, and that the complainant came out the back door to her apartment but then he changed his story saying that she came out the front door to of her apartment to confront him. The complainant stated that the defendant stated that the complainant came with a gun, though he did not see the gun. The complainant stated that she was laying in bed, heard a glass window in the back door break, jumped up, ran to the back door, and saw the defendant walking away from the door, holding a green stuffed animal with a knife. Apartment management stated the cost to repair the window was $200.
There's a lot of randomness in it, Judge.
The only thing, my concern is, who broke the window? Did he break the window?
Thank you, Your Honor. So, according to the DMs, what the complainant says is that she saw him walking away. She heard the broken window. She came downstairs and saw him walking away. And then that's what we have in the DMs. And then I spoke with her yesterday as well. She repeated the same thing, that he was the only one there when the window was broken. And that's what she said. She saw him outside the window door when it was broken.
He's walking away. He actually calls the police because he's being harassed by this woman because she's saying that he broke a window. And I don't think there's any list of physical evidence like glass on him or anything, or in the whatever stuffed animal.
At what point did the cops come and did they arrest him on the spot? What, do we have any other physical evidence? Do they?
We have the two further, the complainant said that he was approximately 20 feet away from the back door when she saw him, and that the officer found the window to be shattered. And then the complainant showed the back door to her apartment.
I mean, how do we know he did it?
No one's saying that he did.
I mean, no one saw, you know? It's,
To be honest, just what we have is that the window was broken, and then she saw him outside at the time when she came downstairs to check on it. That's what we have.
I get it. I
Yes,
get it.
Judge.
I don't think it's enough. However, the fact is, we're still having issues with the same complaining witness. I now have to take more drastic action to ensure nothing happens in the future. So now what I'm going to do is I'm putting an ankle monitor on it and I'm barring him from going within 500 feet of where she lives or where she works.
Yes, Judge. Ankle monitor, just want to make sure it's ELM and not scram.
Correct.
Okay. Acid fees be waived. Okay. I'll add.
How far do they live from each other, Alex? You know?
Do you think that's in the complex?
It was described as across the street. But when I spoke to the complainant, she said that they do not live across the street, that he was staying at a friend's house, but he told the officers that she lives across the street.
So what I'm doing, Mr. Franklin, is I'm going to put a monitor on your ankle and there is a radius of where you cannot go where this person lives or works. And I mean, we may have issues with bond conditions as it is, because if I ordered him not to have weapons on the terroristic threat and they show me that, or they prove to me that you have weapons, I'm going to put your butt in jail. So maybe we should have a formal bond hearing to see if, in fact, you can prove that he has a weapon.
Yeah, Judge.
So I have some hesitancy about everything, Judge, mostly because my client's orange sheet is quite extensive. So the jail has diagnosed multiple mental illnesses. I'm trying to track down his competency because I was appointed, I think, December. So there's been prior competency motions. I'm trying to get the reports from them, which is difficult because I forget what agency does the mental health evaluations. They're saying that they don't exist. So I'm trying to find his mental health records, Judge. It sounds to me like it's bipolar schizophrenia or schizoaffective. And so I think that my client is likely going to have severe mental health issues, which have been causing issues. And I think that's going to be the heart of all this. And so I'm trying to push for treatment. The case is just brand new is the problem.
You ordered not to be in possession of any weapons. And they're telling me now that you have a new case and that you have an alleged knife as well. I want to set this for a formal hearing on Monday. And if they show me that you have a weapon in violation of your bond conditions, I'm going to bring it. Do you understand? You are not to be in possession of any weapons whatsoever. Get a hold of your witnesses.
Yes, Judge.
Get a hold of the cop.
Yes.
Let's have a formal hearing on Monday to show me whether he's in possession of a weapon or not.
Yes, Judge.
Yes, Judge.
In the meantime, like I said, if I find that you become a danger to my community, it's really not going to go well for you. Do you understand, Mr. Franklin? There is no excuse. You will get this ankle monitor today, and you're not to go within 500 feet of where this complaining witness lives or works.
If I can politely ask, Judge, that we reset for more than Monday, only because this case is new enough that there's literally no offense report, so I don't know officers' names or...
Case.
So the new case, the criminal mischief, which will be the allegation for the motion for...
Find no probable cause in the criminal mischief.
Well, but the problem is, Your Honor, is that it's the other criminal mischief that we have the officer that saw the alleged knife. So we'd have to get in contact. We don't have the OR. We have the name. I could reach out, but we don't have the OR to give defense. So they can review it. And
So the allegation is, and it's we don't have an OR, so we're reading DIMS. So the allegation sounds like the officer saw a knife, or maybe the CW saw a knife. It's unclear.
To me, it sounded like both saw a knife. And so
Well,
that's why.
I don't know
So,
if
I
anybody
mean,
did.
I guess I'll give you a full week. You know, that should be sufficient for you to get an OR,
Yes,
get in
yes,
contact
yes,
with both
yes.
witnesses.
just to clarify for both parties here, the officer is the one that said when he contacted him, he found the defendant in possession of the knife.
Okay, let's have a hearing.
Yes, Judge.
Get this guy over here. If you need to subpoena him, do it so that today's Wednesday, we'll have a hearing next Wednesday.
Thank you, Judge.
All right.